is Tolu Olatunji, a lawyer, a mediator, and a mediation advocate. If this is your first time of coming to this channel, you're welcome. You can subscribe, and if you like the video, click on the like button and then the notification button, so each time we post a new video, you can be notified. In this channel, we talk about legal matters, cases that have happened, and how you can learn from them. We provide general advice, general information. So if you need a specific advice, you may need to consult your lawyer or your private chat us. Put your question in the comment section. We'll definitely attend to your questions. So in the previous video, I started a series on divorce. I've talked about the fact that you cannot agree to divorce, but you can agree on some other things like how to maintain the children, how to regulate your relationship going forward, settlement of properties, maintenance of parties. But as to the dissolution of marriage, the court has to find that truly the marriage has broken down irretrievably. This is because the institution of marriage is very sacred, and the courts, just like God, I believe almost every religion frown at divorce. So also the court does not encourage divorce, except when there are facts to show that truly the marriage has broken down irretrievably. So today I'm going to be talking about the divorce procedure. I've had questions where people ask, oh, how long will it take? I want it quickly as possible. But I believe by the time you know what the procedure is, you may be able to factor in, okay, give or take, this is how long it's going to take me. The process or how long it takes depends on the jurisdiction. If you file in a jurisdiction that is very busy, then it's likely to take even up to a year or more. And depending on the facts of the case, if the facts are very contentious, then it may be longer than a divorce that is not defended. You may be wondering, I've started this legal jargon again, so let me break it down. So when you want to file for divorce, you start by what they call petition. So the party that is filing is called the petitioner, and the other party is called the respondent. So when you file the petition, the lawyer knows how to put those documents together. Apart from the petition, there are other documents that has to be attached to the petition. If they are not there, the court may throw out that petition for being irregular. So after filing the petition witness, the petition has to be served on the respondent. We've had situations whereby somebody said, I was not served. How did this happen? Then you can challenge that petition or any divorce gotten without you being served. The court requires that the other party should be served with a copy of the petition. So if the other party now feels that, oh, I want to defend it, then they can file what we call reply. Sometimes you don't want to defend it, you can decide to stay away or just file a notice of address so that you can get notice or get to be served and know the progress of the matter in court. After the reply from the respondent, the petitioner, if he feels that there are some facts that have been raised in the reply, may file a rejoinder, debunking all those facts that have been raised by the respondent. Where the petition could not be served on the respondent, the petitioner is required to bring another application before the court, asking the court to allow it, because every originating process, including the petition, has to be served personally on the respondent. But maybe you don't know where the respondent is living again, you've made all effort to serve and it couldn't be served, you are required to bring an application before the court so that you can serve maybe by email, by posting, by pasting, any other alternative means that, okay, if I post it here, if I send it here, the respondent will definitely get notice of this matter. The essence of service is to give the other party fair hearing. Everybody deserves to be heard. So you cannot just go and do a kangaroo petition and you will not serve. You will just waste your time, because after everything, the other party can come and challenge that procedure. You can imagine how much you have spent, the time you have spent, and the other party get to know that you've gotten a judgment without them being served. They have the right to set that judgment that you got aside. So what happens if the other party responded to your petition? Then, if there's no child or no issue of sharing of properties, you can take a date. Before you take a date for hearing, you file what they call statutory form, stating that, okay, these are many witnesses I'm going to call, and there's no need for compulsory conference and all of that. Then the court will set the matter down for hearing. However, where the other party has some things to say, and the issue of children, maintenance, settlement of property, it is required that you have a compulsory conference. Some relationships are so bad that parties do not even want to see themselves, despite the fact that they have children. It is compulsory that you sit down and talk to your partner on how you're going to take care of those children. You need to make arrangements as to the education of the children, where they will be living, their maintenance. You invited them, so they are not part of your problem. And the parties should stop fighting or using kids to torment one another when you're in a relationship. We've seen instances where the father will deny the mother access to the child, or the mother will say, oh, I suffer so much on these children, therefore the father cannot see the children. It is not right. You are violating the right of those children. It is the right of the children to have access to both parents. Though sometimes the access may be restricted depending on the fact that you have presented before the court, but we always advise that parents should sit down and agree which school are we going to put these children into. What happens then? They will eat, they will wear clothes, they should enjoy life. You have invited them and you have to cater for them. So compulsory conference, it is compulsory where children are involved, and you are able to serve the other party, and the other party is ready to defend the petition. But where the other party did not file anything, did not show, then you are free to continue with the process. In that case, the statutory form will now be that, okay, the matter is undefended. It will be very fast when the matter is not defended. But you see, what really prolong the first proceeding is when you have the issue of, you have to settle the issue of children, you have to settle the issue of properties and all of that, and it will be elongated. For parties to be able to save cost, there is no need in fighting. Try to listen to one another, and as you are negotiating, negotiate what is in the best interest of those children. Please don't let us be selfish. Nobody has a right to the child. No one person has ever given birth. It's combination of efforts. So there can't be mother without a father, and there can't be a father without a mother. So you have to agree as regards to the issue pertaining to children. So when you have now agreed, you file what they call the report of compulsory conference. You can even term it terms of settlement. So that terms of settlement will become an ancillary order to the main order. The main order is the dissolution of the marriage, which I've earlier mentioned in my previous video that party cannot agree to divorce. The court has to look at the fact presented before it and decree or declare that, oh, truly the marriage has broken down. So after you have filed your terms of settlement or report of settlement, a report of compulsory conference, the matter will be stated down for hearing. At the hearing, the petitioner will give evidence, convince the court that the marriage has broken down irretrievably. If the other party feels that I do not agree with the fact that has been presented forward by the petitioner, the respondent may decide to testify. After the testimony of each party, the matter will be adjourned for a written address. In the written address, the lawyer will summarize the evidence that has been given and back it up with his provision, maybe cases, law, or statutory provision, convincing the court that truly the marriage has broken down irretrievably. The court will give judgment and state whether he agreed that the marriage has broken down irretrievably, then pronounce a decree nisi. A decree NISA is in the interim. So within that period that the decree NISA is pronounced and 3 months after, if any of the parties want to challenge anything, you can file to challenge the procedure. You can appeal to the Court of Appeal that, okay, I do not agree with the decision of the court. Okay, this is what had happened. And also, if adequate provision have not been made with regard to the children, that decree will not become absolute, even if after 3 months. So after 3 months, if the arraignment of the children have been settled, if both parties are okay with the judgment of the court, then the decree becomes absolute and both parties will be free to remarry. Mind you, between the period of decree NISA and absolute, you are still husband and wife. And you can't still go and remarry at that point. God forbid, even if one of the parties died. It has happened in the past that before the decree NISA becomes absolute, husband died. In the case of Ifumlayo Isewu and Amobi, that was what happened. The decree NISA has been pronounced, but before it becomes absolute, the man died. So the Amobi, who was the mistress, was still claiming because she has done traditional marriage. Because the traditional marriage was done during the subsistence of the valid marriage. And Odefumlayo was still declared the legal wife because the decree of dissolution of marriage has not become absolute before the husband died. So, if you are a second wife or a mistress, ensure that the previous marriage has been totally dissolved before you contract another marriage. I hope you find this useful. If you find this useful, you can thumbs up, let us know, give us the feedback so that we will be able to bring you more content and be able to answer some of your questions. And thank you for coming around.